problems you might have, what this program has done for over 35 years is answer legal questions and point people in the right direction. And that's what we do here, and that's what we continue to do here. So if you have any legal questions, we encourage you to pick up the phone, give us a call. Here's my number, 330-729-9977. I have 2 lines in Youngstown open for legal calls, 330-729-9977. 330-729-9977 will get you through to us. Let's go to the law firm and see who joins us tonight. Let's hope Mr. Reliable's there, the one and only attorney Mark DeVecchio.
Not tonight. Mark's on vacation.
Mark is on vacation.
Yes, sir.
All right.
I'm back.
All right. So that sounds like the voice of attorney Frank Cassis.
Yes,
Frank,
sir.
welcome back to the program. Then, Frank, will you be doing the program pretty much by yourself then for the next hour?
I'm
wait a
here.
minute.
And
Hold
Frank,
There's somebody here.
it's Attorney Melfi. I heard your voice.
Hey, Ron,
Attorney
how you
James,
doing?
good. Attorney James Melfi's also with us tonight. James, we missed you. Glad to have you back with us. And Attorney Cassis, I guess you guys are both doing the program then tonight, correct?
Yeah.
And
Yeah.
I also will be participating.
Who is that?
David
I-
Beatrice.
Is there a ghost here?
No,
Do you hear son? Do you hear a voice?
it's
I
me.
thought
I'm in live. I'm local. I'm locked and I'm loaded.
there he is, the internet sensation, the one, the only, the kingmaker, the founder of the firm. The legal show brought to you by Beatrice Kopp. That's the voice of attorney David Beatrice. Welcome, David.
Ron,
How
that's
are
a
you,
great
Ron?
introduction. That's like when they introduce Apollo Creed and Rocky.
Yeah.
The master of
Apollo Creed,
disaster.
master.
Yeah, you know what happened to Apollo Creed in 4, though.
Yeah, he died.
It is.
If he
I,
dies, he dies.
Was it 2 weeks ago when Dave was doing a program and Dave was talking? Every time he does it, and I said to Mark DeVecchio when I saw him at the Italian Fest, I said, Dave Beatrice, to all of you folks, he could talk for an hour about his life and what's going on in the world of law. And it's just fascinating to me.
Yeah.
And I said, this is why this guy's a great lawyer, because he holds my attention when he's just talking about anything. I don't care if it's his boat. I don't care if it's about the crazy things that happen to him. Or every time, guys, both of you guys, I hear Dave talk, I think this guy would make an excellent law professor.
Yeah.
He'd be excellent. I always say, well, Dave would make a good judge.
No,
But
no.
No.
I want to be in the arena of battle like I was last week.
What was last week?
I had a jury trial last week in Marion County, Ohio.
why were you in Marion County? It's
a long story, but I was in Marion County, Ohio, on a charge of involuntary manslaughter, not guilty, corrupting another with drugs, guilty, and trafficking in fentanyl, guilty. But I think I discovered a way to get him acquitted on those charges post-verdict. So I filed a Rule 29C motion for acquittal, and we'll see what the judge does with it.
So the decision's been made, but you think you can change it.
So tell Ron what a Rule 29 motion for acquittal is.
So a Rule 29 basically is saying, Judge, as a matter of law, my client should be acquitted. And in 40 years of practicing, it is the first time that this has become an issue, a genuine, real issue in a case.
Well, why?
Well, like when you bake a cake, right? If you want to bake a chocolate cake, you need chocolate and cake mix and butter and salt, flour, blah, blah, blah. So every crime is made up of elements, okay? And the state has to prove each element beyond a reasonable doubt. Now, one of the elements is venue, which is just
Foundational requirement. This is the
but
found.
it's just an, oh, by the way, did this happen in Mahoning County?
Yeah.
Yes, it did. I mean, but the allegation is that my client pled not guilty and he's maintaining in his innocence. The allegation is that my client sold someone fentanyl in Erie County. The gentleman then took the drugs from Erie County to Marion County, allegedly digest them, and died. So they charged him with corrupting another with drugs and
Involuntary manslaughter.
distributing fentanyl and as a direct and proximate result of corrupting another with drugs, caused the death of someone. Well, the jury found him not guilty of involuntary manslaughter. So that was the glue that held the other two together to have Marion County have jurisdiction. It was a course of conduct. But since the jury found him not guilty of that, my client was never in Marion County. They have no evidence of anything happening in Marion County. And so therefore, as a matter of law, he cannot be found guilty because there is no venue without the involuntary manslaughter charge in Marion County. So we'll see how the judge rules on that.
That sounds like a damn good argument to me.
Actually,
What do you guys think?
It's an interesting.
I mean, that's
issue.
really good.
It is. That is something that does
I mean,
not
that's really
happen
sharp.
often.
Yeah.
You don't-
Often, 40 years.
that's what I'm
first
saying.
time.
It doesn't. I mean, it's a very unique issue, and I think personally, I believe it's a winning issue. But we'll see what happens. There's going to be a process that unfolds. It's not going to happen overnight. That's for sure.
Yeah.
Now, let me ask you this, Dave. How did this come to you? And I'm serious. Like, were you driving back afterwards thinking about this in the car to where this?
No, I've been doing this 40 years. And I've never given venue a second thought, right? It's just, the crime. It's happened in Mahoney County? Yeah, happened in Mahoney County. When the jury said not guilty on count 1, but guilty on count 2, okay, and then my client was immediately whisked into custody, bond revoked. I'm laying in bed, and I swear to God, at 2 o'clock in the morning, I got up to go to the bathroom, and I went, wait a minute.
Then he called me.
Yeah, then we all got text messages.
I went, wait a minute. He was found not guilty of proximately causing the death. My client was never in Marion County. How could he be charged with corrupting another with drugs when he's never been in Marion County? He can't be. And that's how it came to me. It just came to me.
At 2 a.m. And did he really text you guys?
Yes.
Yes.
No, I mean, truly. And then for the next 2 days, he called me on the hour, every hour, and said,
I wrote a motion.
He wrote a motion. He sent it to me.
I went
called
to the
me.
boat, and instead of, I got obsessed. Like, I got totally obsessed with this issue. I'm like, it can't be this. It's so obvious that I must be missing something. So I called Jimmy, and I called Frank, and I go, what am I missing? It can't, this makes so much sense, but at the same time, it doesn't make any sense. And they go, no, we think you're right. And then I showed it to a bunch of appellate lawyers and others, and they think it's a real issue.
It's definitely a real issue. It's an interesting.
It'll be in the
issue.
Court of Appeals
Yeah.
regardless of
I
how
think
this
if
goes.
the judge does the right thing, he'll grant my motion for acquittal, because the jury instructions clearly state that on or about this date in Marion County. Let me give you an example. I had a client who was not allowed to own a gun because when he was 16, he had a disability. And most people think that when they turn 18, that goes away. It doesn't. So that stays with you. So my client was not allowed to have a gun. The victim pulled his gun out first, tried to shoot my client, my client pulled out his gun and shot him. And we had a plead because I could win they charged him with murder and aggravated murder. And I could win on a self-defense case, but I couldn't win because while in the commission of a felony, that is being in possession of a firearm, he caused the death of someone.
Right.
That's involuntary manslaughter.
That's involuntary manslaughter. So
That's a legal straitjacket.
Right. But
Yeah.
but it's an interesting issue because like I feel like juries, and this is why I was saying that, I think that juries are smart enough and also they're diligent enough to look at a scenario like that and say, well, okay, at the end of the day, and look, everybody knows Dave talks about it a lot on the show. And when we talk about like the throes of addiction and how horrible the addicts are and what they go through and how sad it is. But at the end of the day, is it always somebody else's fault when you overdose, right? I mean, I feel like they're looking for somebody to blame. And do you blame the addict? Do you blame the dealer? And if you do the research on these issues, most addicts will go to any dealer that will give them drugs. It doesn't matter.
well, what I was fortunate enough in this trial was, and it was a fight. It was a fight to get in evidence that I had that the day before this victim died, he had made a drug purchase from someone else.
Right.
And I said to the jury, what proof do they have that it wasn't that drug that killed him?
Yeah.
Right.
And the jury said, yeah, there's reasonable doubt whether it was your client's drugs or this other guy's drugs. So we're going to find him not guilty of involuntary manslaughter. And unfortunately for the prosecution, they put all their eggs in the
One basket.
in one basket. They never tried to establish venue on the remaining two charges. They were bootstrapping it on the guy died in Marion County through a course of conduct. Well, the jury said, well, the drugs your client supplied him did not kill him. So if that goes away, they can't prove that a drug transaction took place in Marion County.
Right.
So if the judge, it's a hard thing for a judge to do, but if you really study the issue, I think it's a solid issue.
Yeah, that's a real issue. That's not a manifest weight argument going up that you're
No.
hoping and praying. It's a real issue.
Well, and it's where you hope a jury doesn't just look at it and say like, well, who cares? He's a drug dealer. Let him go.
Yeah,
Like when you really break it down, it's very interesting because that's why I think I honestly think philosophically juries look at things and it's all about, I'm a firm believer in any trial, a civil trial, a criminal trial, no matter what it is, it's all about the 12 in Ohio, the 12 or 8 people sitting in the jury box, right? Nothing else
another
matters.
Unique issue in this case, Ron, is so one Marion detective and 2 Erie County detectives go to my client's house and they knock on the door and my client comes outside and they say to him, we want to talk to you. And he goes, what do you want to talk to me about? They go, we want to talk to you about this guy's death. We're not arresting you. And whatever you say, you're going to get to go back in your house and we're going to leave. So they did not have to Mirandize him because it was not a custodial interrogation. And when they told my guy this, he said, well, let's just take it to trial. And they got to use that during the trial, even though I filed a motion to suppress that statement, because I said essentially my guy was invoking his right to remain silent. The case law out there, however, is that you have to actually say, I want my lawyer or I choose to remain silent. Now, I think that's another solid issue. I think if you say, take me to trial as a denial of it, but they got to argue, well, he didn't deny he did it. He just said, take me to trial. And so here we are at trial, and they got to bring that evidence in.
Yeah. So for everybody listening, there's different issues, right? So a motion to suppress evidence is you're stating that a constitutional violation occurred.
Yeah, and so what I said is that they violated my client's constitutional right to remain silent.
Right.
They filed a brief in opposition, and we had a hearing, and the judge ruled that since my client didn't use the magic words, I'm invoking my right to remain silent, or I want my lawyer here, or I'm invoking my Fifth Amendment right. Since he didn't use those magic words, anything he say can be used against him, and his lack of denial is something that they used at trial, saying, well, he didn't deny it. He just said, take me to trial. Now, I think that's a distinction without a difference, but the judge ruled against me, and that evidence got in. So what I want to tell people out there is you can't just say, you could say nothing. You could just be silent. But your silence, if you're in a non-custodial interrogation,
Can be used against you.
can be used against you. You have to say, I'm
Affirmatively.
invoking my Fifth Amendment right.
Or
I want
less,
my lawyer.
Exactly. Less sophisticated. I want a lawyer, or I'm going to hire a lawyer. I
Yeah.
don't want to talk without a lawyer.
But if they say, hey, did you kill this guy? And you sit there dumbfounded. It depends on how that's going to develop through the appellate court. If the judge doesn't grant my motion, I'm going to certainly raise that in the appellate court, because they use his lack of a specific denial.
Well, from our perspective, his silence.
Well, they use that silence.
That's what I'm saying. From our perspective, his silence.
They said, they got up in closing arguments. They said they accused him of killing someone. He didn't say I didn't do it. He said, take me to trial. And here we are at trial. You know, most people, they said, would have said,
no,
I didn't do that.
Right.
Now, it didn't help too much when we were arguing it that they cited a case from the Court of Common Pleas in Claremont County that was affirmed in an appellate court. Do you know who the lawyer on that case was?
Dave Beatrice.
It's pretty bad when
Yeah, that's
they
a tough
cite-
look.
that's
It's a
tough.
tough look.
Yeah.
So I had a case down in Claremont County, and the police approached my client and they said, why did you diddly that little girl? And he said nothing. Okay. And the prosecutor got up an opening statement and said, and when they accused him of doing it, he said nothing. I flew up out of my chair, objected, moved for a mistrial, everything else. Court of Appeals said he did not affirmatively invoke his Fifth Amendment rights, and therefore his silence can be used against him. Now, I think that's ridiculous, and I think that's a distinction without a difference.
Yeah, and
But-
some of the cases are like they didn't invoke his right to counsel when he says, "Should I get a lawyer?" Huh? There's always those cases around too,
Yeah.
and they make a distinction.
So what I
on
want
that.
to tell everyone out there is, if you are being questioned, you should say, I'm invoking my Fifth Amendment right. And then anything after that, and you're even invoking the Fifth Amendment, cannot be used. But your silence in the right prosecutor's hands, under the right circumstances, can in fact be used against you. You have to invoke your constitutional rights.
That and I want my lawyer.
Yeah, and
Two
look,
things you
we're
said.
talking about this in worst case scenario. I mean, we're talking about it in the scenario where somebody is dead, right? But like
Even on a
this applies. No, but I'm saying though, this
DUI.
applies to exactly. It applies to everything.
They pull
Look,
you
any
over for-
any average Joe
would not know this.
would not, and they can get an OVI tonight, tomorrow, in an hour.
Yeah,
And-
and they could get pulled over,
Ye-
and the police officer says, are you drinking? And he sits there and says nothing.
Yeah. Say,
In
I
the
want my
right-
lawyer.
Yeah.
I want my lawyer, or I'm invoking my right to remain
Yeah,
silent.
I mean, it really is, and that's the point, right? So you need to know. David always says it, but there's certain things you have to do if you're pulled over. Tell them.
You have to show them your license, your registration, and insurance, and for the love of everything holy. If they ask you to get out of the car, get out of the car. Because if you don't get out of the car,
They're gonna break your window.
well, then they add another charge called obstruction of justice. Or if you start driving away, it could be a felony, it could be a misdemeanor. If a police officer has the right to ask you to get out of the car, get out of the car.
I love when you do it over the Facebook post that people have the little note on their window. I'm not giving you my license. I'm not telling you my name.
Yeah.
I love when you do
And
the
point
overview.
is
It's
like,
so ridiculous.
Just comply, be respectful, but you don't have to say anything. Give them what they need. Get
No,
out of
no,
the car.
No, see, here's the problem. You don't have to say anything is really a misnomer.
Well,
If you don't want your silence to be used against you, you want to say, I'm invoking my Fifth Amendment right.
So you need to say very little. That's the point, right?
Tell them your name. Give them your
Everybody
driver's
wants
license.
to talk and thinks that, I'm gonna be like, hey, listen, I just had a beer. And I don't care if you just had a beer.
I got a break from my headlines, but I'm sitting here thinking, if that guy didn't pull out a gun, then the one example he gave, he would be dead.
Right.
When he got in trouble.
Doesn't
Back
matter.
with Attorney Beatrice, the legal show brought to you by Beatrice Cop, and more ahead.
Our iHeart Radio Music Festival, presented by Capital One, is back in Vegas.